Ruisech versus Structure Tone.
Good afternoon, Your Honors. May it please the Court. My name is John Lavelle. I'm here on behalf of the appellants. I'd like to reserve 2 minutes at the end for rebuttal if necessary.
Yes.
There are two major issues before the Court here. The first would be the timeliness of the petition for leave to appeal. The second is more of a labor law issue with regard to whether or not what caused the plaintiff to fall was something that's integral to the work. So I'd like to discuss the timeliness issue first. There's an inconsistency between the first and second department with regard to NICEF docketing of notices of entry. In the second department, you can docket an appellate decision with a notice of entry on NICEF directly. In the first department, appellate decisions with notices of entry are actually filed on the trial docket NICEF.
Counselor, is your position that you didn't receive notice? There may be an inconsistency, but I was looking through your papers, and is your position that you didn't know, you didn't receive notice, or just that it's maybe unfair the way?
The position is more the second, Your Honor, more that it's unfair, that the idea of a notice of entry, and before NICEF, you get something in the mail. So you'd have a document come in the mail, you'd open you up and say, okay, you know, we've got to figure this out. In this instance, you have an appellate motion, the full briefing schedule, an appellate decision. That decision ends up in the trial court docket, and your remedy is to go back to the appellate court and then eventually to the Court of Appeals. So it's our position that that structure is inconsistent and insufficient as it's constituted.
And what's our ability to remedy that? Because it sounds like you have some sort of, I don't know if I want to call it a policy complaint or a mode of business complaint about the way these notices of entry are served. What's our power to help you?
So I believe it's an implementation of the system. In other words, at some point in the first department, there are drop-down menus. That option was removed, and that creates an inconsistency within the departments. I do believe it's within the discretion of this court to enforce consistency between the departments to lead to consistent results.
What is it that would allow electronic service of the notice of entry for appeals to the Court of Appeals?
There's a separate system for the Court of Appeals. So
No, I'm sorry. What's that? So when I look at the CPLR, I think it's 2103 sub 7. It authorizes electronic service pursuant to the rules of the chief administrator of the courts for the trial courts. That is, if you look at the statute that authorizes the chief administrator, his authority is limited to, it actually is only limited to certain of the trial courts at the moment. There's pending legislation to expand that to all the trial courts, but it's to the trial courts. Well, so I'm not sure that it's through 2103 that you can get any authority as to the effectiveness of electronic service as regards the Court of Appeals.
So my response to that would be, nonetheless, each of the four departments do have a system.
Correct, because 2103 also starts by saying, unless otherwise authorized by law or court order. And there is an order from the four appellate divisions, a joint order, authorizing electronic service as to them.
Okay.
But we don't have an order like that yet.
Okay.
So what is it that is the statutory basis to conclude that the electronic service, whether it's in the court of instance or it's in the second department, you know, whichever it is effective as regards our timing requirements?
Because what I would say, Your Honor, is the purpose of that notice of entry is to apprise the person not only of the order, but in the court that it's in. And by setting it up the way it's structured, it creates an incongruity for litigants that I believe is unfair and should be remedied by this court.
Well, I understand that. I'm not sure you're answering my question, which is...
I'm doing my best, Your Honor.
I appreciate that. You did say that it used to be you got some paper.
Yes.
Right?
Correct.
So what is it that you think, if you do think, changed that as regards to the Court of Appeals?
Well,
why shouldn't you still be getting paper? What changed?
I don't believe you should, Your Honor. So when NICEF first came out, you'd still be getting papers, and it was very confusing as to when the clock started. Was it NICEF time? Was it mailing? And those things became confusing. But what's happened, especially since COVID, as a practical litigation matter, is people file things in NICEF that the mailings have pretty much stopped. So my point on this issue is, because it's an appellate order, an appellate motion, an appellate decision, if you're going to channel through NICEF, it should be channeled through the appellate NICEF site as opposed to the trial court.
But
So
you
the
have no underlying problem with this court accepting NICEF based service of notices of entries. Is that, you're not disputing that?
I'm not disputing that, no.
So the practice in terms of abandoning mail is just because that has happened, not because of any change in the rules?
That's my understanding, Your Honor. I admittedly could be wrong on that issue, but, I mean, this is what I do all day, every day, and it started with COVID, and it just has pretty much vanished. Everything from BPs to other documents as well used to get motions this thick, and then that was eliminated expressly during COVID. Even, working copies were eliminated by court rules as well, so. And if there's anything else on this issue, I'd like to move to the second issue. So this whole integral to the work issue. So what you have here is there are channels dug out, and there are these large glass partitions, 500-pound pieces of glass. And the channels are dug out first, and then the panels are moved by the workers. So it's not in what they called spoils, or the debris of the channel digging is not integral to the work. That's debris, and it should be debris.
So if you tripped over the channel, that would be different, right?
Of course, there's the famous case, there's a electrical conduit, it's part of the structure, trips over that, okay, that's integral to the work. But in this instance, it's a failure to maintain cleanliness at the site. And there were multiple layers here. So the 241-6 claim with the industrial code sections, and then there were the 200 claims which follow a general negligent structure. And it's our position that the respondents did not meet their burden of proving that there was no constructive notice of them because they couldn't come up with anything. They said there were inspections. They couldn't say when they were last there. They couldn't say when they had last been in the area. There's no written documents, no documentation. And in this case, for a summary judgment motion, the burden rests with them initially and then comes back to us, and they never shifted that burden.
On the 200 negligence issue, do you think this is better looked at as a dangerous condition or a manner of work?
Dangerous condition.
And why is that?
Because it's debris left on the ground, which is slippery condition, and it's not really a matter of work issue. It's a matter of they have to dig out these channels, and there has to be certain debris from that. It's not the manner in which way they're doing it. It's the fact they failed to clean it after the channels were dug out.
And so the failure to clean it properly is not a manner of work?
Correct. If no further questions.
Thank you.
Thank you.
Good afternoon. May it please the court. Allison Snyder with Barry McTiernan and Moore for defendant Structure Tone. We also have we're a move-in. We have a motion to dismiss on the grounds of jurisdiction. And just to address the issue of exactly what the basis is, as the court had requested that the parties brief the issue of what starts the time of whether electronic service through NICEF actually starts the time for leave to appeal. The basis for that is literally found in CPLR 5513B. It says you compute the time from the date of service of the notice of the order being appealed with notice of entry. And in this particular case, there's no dispute that it was a mandatory e-filing case. The chief of the court said that for cases in New York County, beginning in 2012, that those are mandatory e-filed cases. And if you look at the uniform rules, it specifically says that for the filing and service of all documents in an action that's e-filed, that it has to be served by electronic means. And the electronic means is specifically stated is literally just filing on the NICEF site. Now, I understand that there may be some issues with some discrepancy between actually, the first department is the outlier. It's the second, third, and fourth departments that do allow you to go ahead and serve notice of entry or file notice of entry on that particular docket. But that doesn't really matter. The rules specifically say that as long as you file on the NICEF site,
Because you could still, in the other departments, you could file in either or?
Well, it's true. It would be your preference, but I imagine that.
So if the first department changed their rule, here they wouldn't allow it, but if they changed the rule, it would just allow it to be filed in both, right?
Right, and to be honest, I imagine it's just a matter of convenience. If you're appellate counsel, if you know that there's some discrepancy out there that the legislature doesn't see fit to change, then it's a very easy fix. When you're appellate counsel, you just appear in both the underlying action and the appellate division action, and you'll get a notice. The one thing I just wanted to clarify, and I apologize, I noticed as I went through my brief that I was very consistent in misciting the uniform rule that deals with notice of entry. It's 202.5-B, subsection H2. And that specifically says that if you want to serve notice of entry, that you file it with the NICEF site, and that shall constitute service by the filer. And the one thing I just wanted to also clarify is that if you would go ahead and try and serve by other means, it doesn't affect the effectiveness of the service by electronic means. And
What would have happened if you tried to file notice of entry, in this case, on the appellate division docket?
Well, we already know with the first appeal, when the first department granted the defendant's appeal and dismissed the complaint, we went ahead and tried to do that, and the clerk rejected it, sent an email saying, we do things differently in the first department, you're good to go ahead and file that in the, before the court of original jurisdiction, and which we did.
Would your argument be that that's the motivating rationale behind your argument that filing on NICEF is filing on NICEF? It doesn't matter which docket you're filing it on.
Exactly. And then one thing I also wanted to say is that the court specifically, or the rules specific, the uniform rules specifically say that the county clerks are unable to accept paper copies of any documents that in an electronically, in a mandatory e-filing case, they're unable to accept paper copies of any document that must be filed by electronic means. And I just want to...
Had you served notice of entry by mail, in this case, which is a mandatory e-file case, right?
Yes.
That would have been not accepted and potentially ineffective service.
Well, I actually think that, no, I think that it would just be, the plaintiff would have an additional 5 days. I believe, well, actually, I'm sorry, I take that back. I think you would have to do it by electronic
Would a clerk
means.
take it? Is there a clerk somewhere? In a mandatory e-file case, if you tried to file the notice of entry done by mail, would there be a clerk who would take it?
Well, I think you can go ahead and serve by whatever means you want. It's just what you do with your proof of service. And the rules specifically say that if you e-file and you also serve by mail, you don't get the benefit of the extra 5 days. You're confined to the 5 day, or if you then file proof of service, if you e-file proof of service, that doesn't start your time running. So you can serve by whatever means you want, but I believe in, I believe in an e-file case because the rules specifically say it has to be, all filings have to be, filing and service of all documents shall be by electronic means. The only effective way of doing it is by e-filing. If you then do something additional and try and file a paper copy, the clerk literally cannot accept it. And I noticed that in the court's general rules, it says that you don't have to serve notice of entry. Just if you have an order, it's effective on the date that it's issued. But if you want to go ahead and file proof of service by some other means, it has to be in the court of original jurisdiction. And in an e-file case, the only way you're ever going to file that proof of service is literally by filing on NICEF, whether that's, I guess, I don't know why you would want to go ahead and do that proof of service in an appellate division, but if you want to, I guess they would take it. But under 5513B, it's clear that if the date for computing the time of service starts with notice of entry, and in an e-file case you have to serve it by e-filing, then the time automatically commences. There's no other way that you can do it. And the basis for our motion to dismiss was not only to raise that jurisdictional issue and make sure that the plaintiff was taking the position that that the court had waived any issue over the jurisdiction, but also that the plaintiff failed to actually cite the date when he served his papers, and that's obviously essential for determining timeliness. I found one single mention in the plaintiff's papers that he had served his motion on December 23rd, and that's the 31st day. If you go ahead and if we serve notice of entry on November 22nd, and so you begin to start counting on November 23rd, the 30th day is December 22nd, and the plaintiff was 1 day late, and that's just something that he fails to mention over and over again in his brief in terms of timeliness. And I'll go ahead and leave the labor law issues to my colleagues. Thank you.
Good evening, Your Honors. This is C. Briggs Johnson for CBRE. I just wanted to highlight that regarding the notice of entry filed by one party, that starts the clock as to all parties, right? Because when the legislature amended CPLR 5513, it said specifically that it provides for the commencement of time to appeal as running from the time of
So
service.
it's not party by party, it's party
No.
by party?
It's a party
So you're saying everybody gets benefit?
from Structure Tone's notice of entry, that's correct. And as the Second Department said in the Rogowski Farm case, when you look at the statutory text and you're interpreting the statute, the clearest intent of what the legislature wanted to say is in the statutory text. And it says, time to appeal is running from service of order with written
What
notice of
about
entry.
Rottenberg?
Excuse me?
Rottenberg, 91 New York 2nd, 932, with respect to party-by-party approach by this court?
What date is that decision, Your Honor? I'm sorry?
It's 1997.
1997. I don't know specifically when CPLR 5513 was amended, to be honest, and I think that's probably the crucial distinction, because when you say a party, it's not limited to the party serving the notice of entry, or a different party, or the party that's looking to get the benefit of the notice of entry. A party is necessarily unlimited, so it would apply to any party. And, just as I guess, from a standpoint of confusion and burden, right? If you have a complicated case with 35 parties and it's a single order, and all 20 parties file the notice of entry on different days, you're creating a little bit of chaos, because what notice of entry applies to me? Do I have to do the notice of entry, my notice of appeal to their notice of entry, or my other adversary's notice of entry, or the other 23 notices of entry? And, you get a little bit of confusion regarding which one might apply to you, but it's a single order. So I think
CPLR was amended in 97 as well, wasn't it?
553,
5513. Yeah.
So I don't know if that decision predates.
Rottenberg came after. the
Rottenberg came
amendment.
after.
Yeah, where this court said that even after the 1997 amendment requiring analysis about whether the plaintiff's motion to appeal was timely was based on each defendant.
Okay. So I understand, I guess, where you're going with that. So I'm going to turn to the Labor Law 241-6 case.
Perhaps we could go to the labor law issues.
Yes. So, Your Honor, it's undisputed on this record that plaintiff's coworkers created the incidental concrete debris, but it's the dust, it's particles, it's granulates, right? And it's undisputed that they needed to dig the channels, and that it was an inherent and unavoidable byproduct of the ongoing work, right? And there's a legion of cases from the first, second, third, and fourth department that say when you're jackhammering a sidewalk, or when you're doing demolition work.
So then where do you draw the distinction between what you're calling this integral to work particulate matter versus debris that has to be cleared off? Where would you draw that line for the rule?
So can you repeat the question again?
Well, you're arguing this is integral to the work because
Right.
it's created in the process.
Right.
So I assume, though, at some point you agree there is something that would be debris that doesn't fit that definition, so I'm trying to figure out where you draw that line.
Well, yeah, Your Honor, and I think that's a good point. I think the line has to be drawn, and I think it has been drawn a little bit in some of the appellate division decisions. If let's say that a subcontractor is jackhammering a sidewalk, right? And that debris there's big chunks on the ground, right? And then another electrical subcontractor comes in, his work is unrelated to that, and he comes a day later, right? Not only did that contractor have time to remove the debris, but it's unrelated to his work, right? What we're talking about here is a foreman, an experienced construction worker whose coworkers are creating, right, that debris in real time because they need to put the glass into the channels.
And when are they coming in to do the glass?
Excuse me?
relative to when the channel, because my thinking on this is you've got different trades, right? You've got
Right.
the channel digging trade, which
Right.
uses jackhammers or whatever they use.
Right.
And then the glazer trade that comes in and installs the glass. So, I mean, that could be one potential answer to the question you
Sure.
just asked. That's the demarcation between inherent in the work and just general debris.
It
that
can
needs-
be.
Could be.
It could be.
I'm sure you think it's not, but it
Of
could
course,
be.
of course.
So my only question is, what's the time gap between when one trade stopped their work and the other, the glaziers came in to do the glass?
So-
Is it a day, a week?
So in
an
this
hour?
case, plaintiff's employer created the channels. That's his employer's work. That's his coworker's
Yeah,
work.
but it's a different trade.
No, it's the same trade. It's his employer. Him and his coworkers are creating the channels
The
in the
same
ground.
people who installed the glass dug
That's-
out the
yes, yes,
channels?
Yes, yes.
That's what the record.
That's what the
Let's
record
say they
says.
dug the channels one day, they leave all this all over the floor, and the next day they come in with the glass.
Yes.
Same case, same result?
I'm going to say it is, but I'm also going to fall.
Why don't we say what?
Right, so
answer
point
my
2B,
questions?
point 2B of my brief, right, is this is an ongoing construction project in
No,
real
but
time.
let's say in my hypothetical, they
Right.
dig the channel one day.
Right.
Everything stays on the floor, the glaziers come in, the people carrying the glass come in the next day, and they left that on the floor.
I think it's still integral to the work, because plaintiff's own testimony on this record shows that these particles were so small that he could not see them. We're talking about dust. We're talking about very, very, very tiny particles, and when you have a construction project that's
Why does the
ongoing.
size of the particle, how does that bear on whether it's integral to the work or not?
Because if you can't see them, and if a broom can't catch them, right, and if the work is still going
What
on.
about a vacuum?
Excuse me?
A vacuum?
Yes, well, perhaps a vacuum might be able.
That might make you not negligent, or you
Right.
might argue that, but
Right.
how does that make it not integral to the work?
I'm sorry, say the question again?
If you can't see them.
Right.
Perhaps you have an argument that you are not negligent for
Right.
vacuuming them up. My guess is your adversary would say something different to that.
Right, right.
But how does the size bear on whether it's integral to the work or not?
I understand your point, but I think to answer your question, I think I'm going to turn to and I think we're talking about 1.7D of the industrial code at this point, right? Because excuse me, I think I'm kind of jumping ahead of your question. So I think it's integral to the work because it's an inherent and necessary byproduct of the
Yeah,
ongoing
but that
work.
doesn't seem to bear on the size, right?
Sure, that's fine. And I understand that, right? Because when you're jackhammering a sidewalk and the debris is huge, the courts have said that's inherent byproduct of the work,
And if it
too.
was left, to return to Judge Garcia's question, if it was left for a week, would that make any difference?
I think there is case law from the appellate division, right, where let's say there's debris around for 3 months, right? You leave a piece of plywood, or you have rocks there for 4 months. You can't say that's integral to the work, right? There's too much of a time
Can I
gap.
can I ask
integral.
how you're defining work? What's
this
the
case?
wor- Yes, yes.
Well, I used this court's definition, which was the O'Brien case from 2006, which is integral to the work applies not only to plaintiff's work, but to the construction project generally. So it doesn't have to be
What
plaintiff's
about
work.
our most recent case, Basdurek? How do you reconcile that?
This case with Basdurek?
Yeah.
Well, I think,
Where we said it's the task that you're doing at the time as opposed to the general work.
that's a fair point, but I think, the facts in this case are a lot different than Basdurek, right? Because in Basdurek, the plastic covering was not only not part of the functionality of the elevator, but it was undisputed at that point that it had nothing to do with the work and that there was a safer alternative, right?
Well, it had something to do with the work.
Right, but it had nothing to do with the functionality of the elevator, in this court's own words, right? But if we get to 1.7D, which is foreign substance, right? We're talking about the tarp being a foreign substance to the elevator. This debris is inherent in the work. The particles are inherent byproduct of the work. So the tarp in Basdurek was foreign to the work, but plaintiff's coworkers are digging the channel in real time. So you can't say that the particles that were created by the jackhammering work were foreign
I'm a
substance.
little confused. When you say real time, I know your red light is on here.
I'm sorry.
When you're saying real time,
Yes.
do you mean that there are still construction workers who are indeed creating this channel while people are coming in with these 500-pound plates of
No,
glass?
I didn't mean to say that. I didn't
Oh,
mean to say
okay.
that.
So I
Yeah, I meant to say that the work is still ongoing, right? The glass installation work is not yet completed. So the channels are dug, and they're in the process of installing the glass into
So
the
then,
channels.
so then that would, what you just explained would apply to Judge Garcia's example where you finished with the channels Monday and the glass is coming in on Tuesday?
So,
Is that the way you meant that?
I'm sorry.
That's all part of the same work task?
I
It's
think,
happening in real time,
yeah, I think it's all part of the same,
even though there's been an overnight break? And
I
you
think-
finished one task and you're moving on to the other?
I think it's the same work. I think it's all part of the same work, right? So the work for that subcontractor has not finished yet.
But couldn't you say that about basically the whole project? Like, it isn't done yet, so we can leave the debris on the floor, and then we're going to finish the project at some point. I mean, it seems to me the integral to the work argument in the purest sense in this
Right.
case would be, because of the nature of the surface, you have to dig the channel and slide the glass in at the same time, almost. You
Right.
dig the channel, you slide it in, or else it's not going to work. But that's not what happened here, right? It's just you took a while to get the glass out, and you had the channels dug, but you hadn't cleaned up the debris yet.
Well, the record's unclear on how long the debris has been there. I mean, to be honest, the plaintiff doesn't know how long it was there. I mean, the channels could have been dug earlier that day for all we know, but the testimony doesn't reveal itself in that.
Or a
in that
week
respect.
earlier.
Excuse me?
Or a week earlier.
Well, yes, that's a
Whose
possibility.
burden is it to show that?
I understand what you're saying. And I would just, I know my time is up. If I could just, on 1.7D, when we talk about foreign substance, right? Ice, water, grease, something that is foreign to the work, right? The tarp and Basdirac was foreign to the
Well, the
elevator.
grease could come from a piece, it could have come from the equipment used to dig the channel.
Excuse me?
Grease could have, for example, come from a piece of equipment used to dig the channel.
Right, but grease is specifically enumerated in 1.7D. Debris that is an inherent a necessary byproduct of the work is not, and especially in this case, when it's a necessary byproduct of the work. And that's the point I'm trying to make. I appreciate your time today. Thank you.
Good afternoon, Your Honors. My name is Louise Cherkis, and I represent Tishman Spire Properties LP and 200 Park LP. And that's actually particularly important here in the Tishman Spire Properties LP and 200 Park LP were really not discussed at all in the brief by plaintiff before this court, and to the extent that they were mentioned at all, they were mischaracterized as being the, having had the contract with Structure Tone. What they are is the owner of the building, who was an out-of-possession owner who, prior to this whole construction being done, had a tenant, the tenant being CBRE, who entered a CBRE that had the contract with Structure Tone, and then Structure Tone had its subcontract with AVAL. And my particular concern about this is not, you start off with that, and then all the analyses about who was there, what day, and this and that. We were, you not only have that we were the out-of-possession owner, but with regard to 200, that's 200 Park, but with Tishman Spire, the 241-6 complaint allegations were dismissed in the lower court. The lower court meaning the trial court. And it was not appealed by plaintiff, and so for plaintiff to now be coming before Your Honors, lumping Tishman involved with any of this with 241-6 should be beyond the court even taking any consideration of it, even were the court to accept plaintiff's arguments with regard to the other.
I understand your procedural point.
Yeah.
On the substantive point, do you know of case law as to 241-6 that says an out-of-possession owner is not liable?
well, here, the out of possession, the out of possession owner here, well, we did not, well, we didn't,
I'm not asking about the facts of the case, I'm just asking for case law. If, that is, it might be a proposition of law that an out-of-possession owner of a building, where an in-possession owner might be liable under 241-6, an out-of-possession owner might be exempt. Do you know of any cases saying that?
well, off the top of my head right now, standing in front of you, I'm not thinking of a case. I do
Okay.
believe, I do have cases written in the briefing, but I would go forward to the 200 in common law, also where we didn't, neither one of us, we didn't create a condition. We were the ad possession owner, the agent, we weren't, that wasn't our agent, you know, and all that was gone on that. We weren't involved in the project at all. I also would say with regard to plaintiff himself, that the plaintiff, it's awkward to think the plaintiff can create a issue of fact here when the plaintiff himself does not know with regard to the channel when it was created in the first place. That's plaintiff who does not present that, and yet he is an employee of the trade who did put in the channel itself, and he was an experienced worker who was used to the routine of putting in these glass panels once there was a cut put in. It's also, I just want to remind the court that where this happened, he was right at the channel. He's in these minute pieces. They're very minute. While he had said he had seen debris before, he had never seen these minute pieces before. And I think it all together is part of that this is all, it was all integral to the work. His role in the project would include the channels being there was an essential part of his. It's not a part of this huge to say that the whole construction project, you know, would be integral. No, it's just that for him to perform his chore, those channels had to be right there, and he was right there, and again, he did not know, and he did not, and of course we know that he also did not fall
Thank you, counsel.
either.
Thank you.
But thank you.
The only thing that I'd like to issue, just to point out to the court, is under 23-1.7D, the statute in addition to the enumerated things, says any other foreign substance which may cause slippery footing shall be removed. So it falls into that category. Thank you for your time.
Can I
Can I just
before
ask you
sit-
what your position, oh, I'm sorry.
Go ahead, no, go ahead.
Your position on Tishman's liability under 200, is there an argument in response to what was just stated?
No, Your Honor.
Okay.
I just want to be clear, can the glass be put in this channel if there's debris in the channel? Like, how do they ensure there's no debris in the channel?
That was not actually fleshed out in the record. The one thing that is in the record, though, Your Honor, is there were basically two teams. One did channeling and one did glass installation, and plaintiff was on the glass installation team. So there is that temporal gap, which I believe should give rise to liability. At the very least, a question of fact, because that's why we're here today.
Thank you.
Thank you.